And look, if she wins the motion, ultimately she wins. But you don't do it by standing there 3 feet from you in your face and lying to the court. And that's what she did. And she knew what she was doing, and it's not right.
The RICO trial against rapper Young Thug and his co-defendants is on pause yet again, off Thursday and Friday, with court resuming Monday. And when court is back in session, some major arguments from this week will come into play. We are looking at some of the most explosive moments in the Atlanta courtroom this past week. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. There have been some tense moments in the courtroom between the judge, the prosecutor, and defense counsel in the Young Thug RICO trial out of Atlanta, Georgia, and we are going to break it all down. So Young Thug, whose real name is Jeffrey Williams, he was indicted on a laundry list of RICO or racketeering charges that accuse him of leading a criminal organization known as YSL, or Young Slime Life. And when we talk about the main underlying charge, conspiracy to violate the RICO statute, there has to be an agreement to break the law, and there have to be overt acts or steps that are taken in furtherance of that agreement. Now, overt acts, they don't have to necessarily be crimes. They just have to be certain actions that were taken. The idea is that Williams and others had an agreement to participate in gang activities, and there are 191 overt acts taken in furtherance of the YSL gang. That is what is being alleged by the prosecution, and that is what they're hoping to prove. Kind of gives you an idea of the scope and length of this trial. Well, more than 24 other men were originally charged, but that number has dwindled down by the time we got to the start of this trial. That was for various reasons. Their cases were severed, they took plea deals, but now we have this trial. The defense is suggesting that YSL is merely a record label, that there is no gang, that there is no criminal enterprise here. And from a legal point of view, one way to defeat the RICO claim is to say that any crimes that were committed, they were done by individuals in their individual capacity, not to further the criminal enterprise. Now, putting all that to a side, the trial has been a spectacle. It has, basically from the very beginning. And it has been marked by not only the slow pace, but also the tension between all of the parties involved. For example, at the end of last week, things got pretty heated when the judge excluded some evidence that the prosecution wanted to introduce. Judge Ural Glanville had an issue of timing of the introduction of this evidence.
I'm not going to do this anymore. I'm just not. We are starting right now. It's 1:20. So
we have talked to them. We have said we don't agree.
Then file a motion and get it before me, and we'll take it up. Both of you all have equally responsibility to do that. Oh, it's going to be inadmissible right now.
I'm saying, Judge, that you said to file a motion. There's nothing.
I'm not going to have any more discussion about this, madam. I'm not.
Talk to them this morning
I don't.
About that.
Well, you know what?
And I attempted to try to talk to them earlier this week.
Well, then that's why we have to.
So the court punishes the state because the defense.
I'm not punishing anybody, but but prior preparation prevents poor performance.
Be prepared, Judge. That's why I sent them what I sent them last week, a whole week and a half ago, 2 weeks. Your
I'm
Honor.
not. Well,
and I have asked. I have said I would like to discuss.
Our jury's coming in, madam. Our jury's coming in. Have a seat.
We told you before about how slow this trial has been moving. Jury selection started in January of 2023. It took almost a year just to seat the jury. It's been 5 months since opening statements, and the prosecution is only part of the way through its massive witness list. So, by all accounts, this will likely go well into 2025. Now, let's talk about a standoff between Judge Glanville and one of Williams' attorneys, Brian Steele. So there was an argument over whether a person testifying could be considered an expert witness. Now, typically, there's what's called a Daubert hearing. The judge hears arguments as to why this person would qualify as an expert. The defense, though, Brian Steele, he was not too happy with how one witness, former Atlanta investigator Lakeia Gaither, was qualified in front of the jury, qualified as a gang expert. Steele seemed to be especially not happy about how the judge referred to Gaither in front of the jury.
So my point is, there was absolute candor always with the court. I did take it as a fait accompli because I don't know why.
No, but that's not true, sir. And that's a misstatement and a mischaracterization. You're telling me that I've already made up my mind at that point in time. It was all but a certain conclusion. It was not, sir. That's not the way that this court looks at its role as the gatekeeper and its role as a referee.
Well, I understand that you're offended.
I am offended because it's not true in terms of what you were given.
Well, I'm going to tell you I'm offended because no other time in this trial have you given a instruction to the jury before you found somebody expert to say this person's going to give expert and lay testimony. So as a listener, it was already a fait accompli because you already instructed the jury that that witness was going to provide expert and lay testimony.
Did you object at that point in time?
Your Honor, I believe...
Did you object at that point in time?
I believe you already...
Did you object at that point in time, sir? I'm asking you a question. Did you object to, at that point in time, saying, Judge, she hasn't been qualified as an expert as of yet? I don't think you should read that instruction as of yet.
It would have been frivolous to say...
But you didn't object, though, did you?
Listen, I'm not playing...
I know I'm not... I'm asking you, look.
I'm just saying, to me, there's nothing but candor in my motion always with the court. I love this court. I'm not attacking you. I'm telling you how it appeared to a reasonable person.
Well, Gaither did end up testifying over several days, and she spoke about how the investigation into Walter D.K. Murphy, the alleged co-founder of YSL, and a man named D'Angelo White. White was allegedly the victim of an attempted murder back in 2015. He spoke previously on the stand saying he's not a victim, he wasn't hurt, didn't want to testify. Another man, Dexter Montgomery, was shot in the head, so his memory was really not the best. So what does this have to do with Mr. Williams or any of the other defendants in the room? Well, they're not being accused of committing this crime per se, but prosecutors are saying that this is an overt act, saying it was ordered or was done in furtherance for YSL. So the jury heard taped interviews between Atlanta police detectives and D'Angelo White during Gaither's testimony. Williams was mentioned a few times, but the voices were kind of hard to make out on the tape, so who knows if the jury was really able to take anything away from it. But let's go to Wednesday, because Wednesday was punctuated by nearly constant sidebars and bench conferences. The attorneys were called up to the bench multiple times to discuss motions or objections with the judge. This was out of earshot of the jurors. And one of those sidebars was to discuss a video that had been posted to social media back in 2015.
Sergeant Gaither, I'm going to ask you a few more questions about State's Exhibit 112, Bravo, Bravo. Did you recognize the person who was depicted in the video visually?
Yes.
All right. And did you recognize the voice of the person depicted in the video?
Yes.
Was the video obtained from a public social media site that was accessible to anyone who is looking at that site?
Yes.
Okay. We will come back to that.
This hours-long argument involved a 15-second video posted to an Instagram page back in 2015 that shows Williams looking right into the camera. The gist of it is that Williams allegedly has a message from YSL: if you snitch, you'll be killed. In the video, you can hear multiple people in the background seemingly making comments in agreement with what Williams is saying. While the prosecution says the video points to gang and criminal activity, the defense was saying that there's really no way to authenticate when it happened, what it was in reference to, or who was there with Williams at the time. So this is actually a good sampling of the whole theme in this trial.
What gang was it that you were charging them with committing crimes in furtherance of?
YSL.
Basis, sir. I'm going to overrule the objection.
You may answer.
YSL.
Thank you. And Your Honor, with the exception of the video that we are redacting with the court's ruling, I don't have any further questions at this time. With the court's permission to play that video after it's properly redacted, and defense has had an opportunity to look at it.
Counsel, can I see you for a second, please? Just.
Hey there, everybody. So I want to thank Morgan & Morgan for sponsoring this episode of Sidebar. Always love talking about them. Now, here is the incredible thing about Morgan & Morgan, and one of the reasons why I like talking about them so much.
Hey, say something about our big wins.
You're not supposed to come on camera. The reason Morgan & Morgan, America's largest personal injury law firm, is so big, and I'm sure you can guess it, is because they win a lot. And that's
Don't forget huge verdicts.
Yeah, I was. They've won big verdicts. $6.8 million in New York, $26 million in Philadelphia. You see, the thing about them is they don't settle for lowball insurance offers from insurance companies, which is something.
Mention that you can submit a claim from your couch at home and on your phone.
Dan, they've completely modernized the process by submitting your claim, talking to your legal team. It's all done straight from your smartphone. Again, that's something
With
that
8 clicks or less.
8 clicks or less. Yes. You can see if you have a case in just a few minutes.
1,000 lawyers. We have over 1,000 lawyers.
All right.
now.
You know what, Dan? If you really think you can do better, maybe you should just do it yourself.
What Jesse was getting at is if you've ever been injured in an accident, you can check out Morgan & Morgan. You can submit a claim in 8 clicks or less. To start your claim, just visit forthepeople.com/LC Sidebar.
You came a little too close to me. It hurt me a little bit. I'm probably actually going to have to hire you guys now, but that was well said. That was well said.
He is putting forth himself as a figurehead. He's saying that's for me and my gang, me and YSL. Y'all need to be killed. Those words are wholly inconsistent with this notion that we just produce rap music for the good of everybody. And so, Judge, given that the speaker of the snitching comment is doing nothing but co-signing the main message that Mr. Williams is speaking, the first contention that identification of all speakers is necessary before tapes are admitted refers to one of 7 requirements often enunciated by courts for the admission of tape recordings. But the primary aim of these requirements is to give the assurance that the tapes are accurate. The goal of accuracy is sufficiently satisfied even when all the speakers are not identified, as long as relevant speakers are. In the challenge recordings in Bagley, the court found that the more relevant party was the caller, who in each case was an identified member of the conspiracy, and insofar as the conversations may be deciphered to involve the heroin scheme, the names of the recipients of the calls were not critical to the tape's accuracy or their relevance. Therefore, the trial court properly admitted them despite the failure to identify every party. So for our purposes, as we've alleged and stated from the beginning, the person that we identified in the overt act listed in the indictment was Mr. Williams. His words were the overt act that we alleged in the indictment in Act 26. Mr. Williams is the relevant speaker. His words are the relevant words, and the persons who are behind him talking are simply co-signing.
Okay, you said that twice now. Okay, at least
I won't say it again.
All right, so let me hear from your colleagues across the table.
It's a repost. What you're being shown is a repost. Are they the same statement? People change things all the time. Like the state was going to redact here. In the background, we started out with the state saying you only hear yeah by other identified persons. You clearly hear the person saying, I'm going to lie on God. Snitching, I'm not going to say it, but B-I-T blank A-C-H-E-S. F and then the N blank G-G-A. That's as far as I can blank you. So help you God. It's 17 seconds and there are multiple speakers. It's not just 2 speakers, it's multiple speakers. that right now the state may be able to get it in. It's just like you told me. I'm not saying this may not be evidence that's important to the case. What I'm saying is there has to be the same foundation that the state lays that you're making me lay, and that's what the case law supports. Now, if you let it in, an appellate court, they may say it was error, harmless error, it wasn't an abuse of discretion, it wasn't abuse of discretion. We understand that, but we're here now. The state cannot lay the foundation. They need a different witness.
Okay. The court's had an opportunity to kind of consider the issue presented to it as to the exhibit. That being states 112 Bravo Bravo, the digital media of the incident involving the posting of January 26th of 2015. I'm going to sustain the objection as to foundation at this time. However, much like many of the rulings I've made, they're subject to reconsideration. In this particular circumstance, I believe that it is the opinion of the court that the original video as presented would at least the source would have to be at least identified for the purposes to make sure that there were no alterations of that particular video. I don't know whether or not they are, but I think that'd be part of the foundation in this case. So, for example, when we haven't had testimony of this quite yet, if it can be shown that this particular video came from Mr. Williams' Instagram page or some other social media site, and it's public and posted, and then it was re-grabbed and reposted, then that would finish the foundation for in the court's opinion. And the other issues that the court would take up at that point in time as to what it would play and for what purpose.
By the way, during all of this, the jury's not present. They're in the back waiting to be called in. And they have been waiting for hours during the course of this trial while the attorneys and the judge work out issues like this. It's like, it's not easy sitting on a jury in any case, but this one especially feels particularly difficult. And Judge Glanville is not happy about that. He is not happy about how slow things are going, how the jurors are kept to be waiting, and he just wants things to move along. But the arguments weren't over. Keith Adams, another of Williams' attorneys, told the judge that he needed to say something on the record. And what was that? Well, he ended up calling out prosecutor Adriane Love for allegedly not being honest to the judge's face.
I've got to say this because I've been sitting there after our conversations. Let me just preface it by saying, in any of our objections, whatever, you make a ruling, sometimes we win, sometimes we lose, we move on. That's fine. If after your ruling, I've got a case that I want to bring to your attention, I say, Judge, reconsider your ruling based on this case, and you consider it, that's fine. If you don't want to consider it, that's fine too. But what I found objectionable, and I want the court to address with the state, is what happened at the bench earlier. There was an objection to the video, you made a ruling, we moved on. The state came back up and made representations to you. And they weren't representations based upon some new case law that they had found. There were representations, misrepresentations that were made directly to you, all of us standing there right there at the bench. She said something very, very fact specific in an attempt to get you to readdress the issue again. Madam Prosecutor said, I want you to listen to the 17-second video, because what you had based your ruling on was that the parties in the background couldn't be identified, right? And Madam Prosecutor said to you, and was not accurate, and I'm going to be charitable and say that she was disingenuous. What she said was, these people in the background, the only thing that you hear are people saying, yeah, yeah. That's it. When Mr. Steele corrected her and said that's not true, she said, Mrs. Steele is not accurate. What Mrs. Steele just told you is not true. The only thing you can hear in the background is yeah, yeah. And actually, when she stepped up there, it was in an attempt to act as though she didn't know what your ruling previously was, because their attempt was to go ahead and play the video at that time, despite your previous ruling. My point is this. After you decided to reconsider, you want to hear the video yourself, you had a chance to hear it. You had a chance to hear what we had already heard, what we knew it said, what they knew it said. And there are at least 5 or 6 different things on that video audio that were in contradiction of what Madam Prosecutor said. On God, snitching, I'ma tell a lie on God. That's what I'm talking about. No back and forth with you, bro. I'm not just saying that for emphasis. I'm saying that because what she said to you was inaccurate. At some point, Your Honor, I'm asking you to, we've had this conversation about candor with the court over the course of the past number of weeks.
3.3.
Yeah, we've had that conversation about it. And when we step up to you and we make a representation, it ought to be candid and it ought to be truthful. And what she said, and look, if she wins the motion, ultimately she wins. But you don't do it by standing there 3 feet from you in your face and lying to the court. And that's what she did. And she knew what she was doing, and it's not right.
I would not have asked the court to listen to the 17-second video.
But what you did tell me, Ms. Love, wasn't the entirety of what was purportedly on states 112 Bravo. It did have other statements on it. It's different if you'd have told me, Judge, there are statements on there. Probably need to listen to them for yourself. Not just yeah.
Your Honor, my recollection, and I'm going to speak candidly because it's been
I would
all
hope
along.
there would be nothing less than candor.
And Your Honor, that's what I've been pushing for all along. There have been times, as the court is aware, that we have been at the bench and misrepresentations, bald misrepresentations have been made, and the court has seen my reaction to them. I am the one that's constantly saying I have a duty of candor to the court.
All of you do. All of you do.
We do. And when Mr. Adams just read those series of things that he read, those half of what he said, I didn't catch. The part that I did catch and remember is the part I kept repeating just now, snitching. And I didn't even recall that part was there.
Zealous advocacy is one thing, but it should never be confused for misstatements or for anything else that's not less than candid to the court. I think both sides, you all are fighting very diligently and valiantly about your respective sides. And as I said a couple of days ago, what the public sees is, there's friction between the state, the defense, and the court. That is natural, and it is good for the system because it shows that we are not in collusion with one another. Justice is what it will be, and whatever this jury will decide. But what I am going to just advise everyone to kind of relook is what you tell each other, what you tell me, because there have been times where I have not received, I would consider what is accurate information. Let me just put it that way.
Oh boy. Testimony resumes on Monday. We'll see if these administrative days and the weekend have given everybody some time to cool off a bit. That's all we have for you here on Sidebar, everybody. Thank you so much for joining us. As always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.